Members of the jury, at the outset, the court wishes to take this opportunity of thanking the jury for the cooperation to the court for coming here early this morning and at other such times that the court requested that the jury be in the courtroom. It is because of the cooperation of the juries that we have in New York and Bronx counties that we have been able to move our calendar and to do substantial justice to those who come into our forum. Now, the court also desires to thank the prosecuting attorney and the attorney for the defendant. I know both of these gentlemen well. I want to thank them for their courteous and respectful manner in which they each conducted themselves. I wish to say to you that they tried this case to the best of their ability, which is the duty of any lawyer who steps into the trial of a case. However, we are not trying the lawyers in this case. We are trying an issue in which the parties are the people on the one hand and the defendant on the other. And the determination must be on the evidence and on the law fairly, justly, and impartially to each party. Members of the jury, we have reached that point in this case where it becomes incumbent upon the court to charge you with respect to the applicable law that governs a case of this character. Now, you members of the jury must have become familiar with the fact, those of you who have served before, that we are both the judges in a very real sense. I am the judge of the law, and you are bound by your oath which you took prior to being selected as a juror to take and accept the law from the court as I set it down. There is no discretion whatsoever on the part of any juror to divert from the principles of law which are set down by the court. Now you, on the other hand, are the sole and exclusive judges of the facts. That's your province. No one may in any way invade the jurisdiction of yours in that respect, and you will examine into the facts calmly and carefully in the light of the law which is set down by the court, and in that manner you will determine your verdict. Now, it is my custom, and I do this in the interest of clarification for practical reasons and convenience, to divide my charge, my instructions to the jury, in two portions or two parts, the first part of which is devoted to certain principles of law which are applicable to criminal cases generally. That means every criminal case has these essential general principles with few modifications. And the second part of my charge, and lastly, I will relate certain additional principles of law applicable to this case. We will examine into the indictment, and I will define to you the elements of the crimes charged in this indictment, upon which you will deliberate and render your verdict in this case. Now, it is the duty of each juror to decide the guilt or innocence of this defendant solely on the evidence produced and on the law which I will explain to you. You are to disregard the fact that I may have denied motions of counsel on either side during the course of this trial. Disregard also the fact that I may have overruled or sustained objections by counsel. These are matters of law. They do not concern you, and in no way should you be concerned by it at all. Attempts by counsel to introduce evidence which the court excluded, and of course any and all colloquy which was had between counsel and sometimes the court, if that happened, must be disregarded by you in your deliberations. Such incidents of necessity must occur in the course of trial, with the heat of battle and the zealousness of attorney with respect to their cause. So far as colloquy is concerned, that means comments by and between counsel, and if the court participated in such comments, forget about it. It's not part of this trial. Unanswered questions are not evidence and should not be considered by you. It is the questions and the answers that can be considered by you. It is the questions and the answers that can be considered and weighed in determining the credibility of respective witnesses. You are